The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Next case is State versus Blagg, and we'll hear from the appellant.
Good morning, Your Honors. May it please the court, my name is Sean Vitrano. It's my privilege to represent the defendant appellant Charles Blagg. I'd like to reserve 10 minutes of my time for rebuttal this morning, please. Mr. Blagg is appealing as of right from a dissent and asks this court to reverse the Court of Appeals and vacate his conviction of possession with intent to sell or deliver methamphetamine. As the court is aware, the elements of the offense of possession with intent to sell and deliver methamphetamine are possession of a controlled substance, here methamphetamine, and the intent to sell or deliver. The question before this court is whether the state presented sufficient circumstantial evidence to support a reasonable inference of intent to sell or deliver. And we're here on de novo review. The evidence has to be substantial. Substantial evidence, of course, is that amount of relevant evidence that a reasonable mind might accept as adequate to support a conclusion. And as the court knows, the evidence is viewed in the light most favorable to the state, making all reasonable inferences in favor of the state. But when the evidence is sufficient only to raise a suspicion or conjecture as to the commission of the offense, a motion to dismiss has to be allowed. I'd like to describe what was found in Mr. Blagg's car and then explain why I don't think that evidence supports a reasonable inference that he intended to sell or deliver methamphetamine. As to the facts, the Buncombe County Sheriff's Office deputies were conducting surveillance of a home in Weaverville in January 2017. After dark, a four-door Ford Focus sedan pulled into the driveway and a person went inside the residence for about 10 minutes. A deputy, Daryl Maxwell, followed the Ford when it left, executed a traffic stop, and ultimately searched the car. Mr. Blagg was the driver and the sole occupant of the car. The car was registered to his mom. Inside the center console of the Ford, the police found packages of rolling papers, a baggie containing 3.5 grams of marijuana, an unopened package of syringes, and 3 clear plastic bags containing a crystalline substance weighing 0.6, 0.9, and 7.1 grams. One of the baggies of crystalline substance was tested, and it was determined to contain 6.5 grams, 6.51 grams of methamphetamine. The trial court instructed the jury not to consider the contents of the other 2 baggies as they were not proven to contain controlled substances. They were never tested. Under the rear passenger floor mat of the Ford, the officers found a camouflage lockbox that contained the following: 2 chapstick containers, an Advil container containing some smoked marijuana blunts, a letter addressed to Charlie Baby, a number of empty plastic baggies, a used syringe with a bloodish-colored substance in it, and a rubber band that Deputy Maxwell testified was used for a tourniquet when somebody is going to insert a syringe in their arm. Next to that lockbox, there was a larger plastic bag that had a black pouch in it which contained a package of cotton balls. And Deputy Maxwell testified that the cotton balls were used once the crystal meth is melted down. He said they used that to inject it into a syringe. They used the cotton balls to filter it. Mr. Blagg was in possession also of 1 cell phone, and Deputy Maxwell testified that it was seized and forensically examined, and it provided no evidence of any drug activity. Deputies Maxwell and Lambert also testified that there was no cash in the vehicle or on Mr. Blagg's person. There were no books, ledgers, records, or other papers that were indicative of any drug dealing activity. There were no cutting agents like rock salt, which is used to increase the volume of the product. There were no scales to weigh out any of the product, and there were no weapons, such as firearms, to protect the product. So I'd like to break down the factors that are laid out in Nettles and Wilkins, specifically the quantity, the packaging, whether or not there was paraphernalia, and the defendant's activities. And I'll start with the quantity of the methamphetamine that was found. It's our position that the quantity alone, and I don't think the state actually contests this, our position is that the quantity alone, 6.51 grams, is not itself sufficient to infer an intent to sell or deliver. This court knows that under Williams and Morgan, quantity alone can give rise to an inference of intent to sell or deliver, but only if the amount of drugs is found to be substantial. And the main
Do you concede that there was testimony that a user amount is anywhere from a half to a gram, and that there was evidence that if you look at a user amount of a half a gram, that there were multiple dosages based on that?
Justice Newby, we don't concede that. The deputy was talking about how he sees methamphetamine typically packaged. In this case, the state offered no evidence that the amount that was discovered in the car was more than an individual would possess for personal use. Maxwell testified about how methamphetamine had been packaged in his experience. He didn't testify about the doses that an average meth user would consume. So we don't know, this court doesn't know, what an individual serving of meth is. We don't know whether 6.5 grams is 6 doses or 13 doses or some other amount. And in this case, the trial court specifically prohibited the state from arguing that this was more than personal use, finding absolutely no evidence that 6.5 grams was more than personal use. So
you think we have to read very in a limited nature. So the question was, what are the ways that you typically see methamphetamine packaged? And then the answer was, usually a seller will individually package the substance, usually in anywhere from half a gram to 1 gram, depending on what the buyer is wanting. On occasion, they'll weigh out and repackage it and sell whatever the buyer is seeking. So it's your position that the testimony is inadequate to support a finder of fact believing that an individual package, individual dosage is anywhere from a half a gram to 1 gram?
we think that more is required, more testimony would have been required to support that. Because where Deputy Maxwell was testifying, the initial question was about the baggies that he saw that contained the methamphetamine. He initially testified that the plastic baggie containing that 6.5 grams was consistent with his experience as to the dealing and transportation, both dealing and transportation of methamphetamine. And then, as I read his testimony was that he had seen in his experience methamphetamine packaged in half gram to 1 gram quantities, but also that he had seen different amounts based on what a buyer was seeking. And so this is not a case like McNeil or Holmes, which the state cited in its memo of additional authorities, where the drugs were clearly packaged in quantities ready for street level sales. The court will recall that in the McNeil case, there were 5.5 grams of cocaine, and the cocaine was packaged in 22 different pieces separately. In Holmes, for example, there was a pouch under the driver's seat of the defendant's car, and that contained 22 baggies, each containing a small amount of cocaine, and they were tied up with twist ties. The officer testified in that case that those bags were packaged for street level sales. Here, our contention is that this is more like Wilkins and Nettles, where the Court of Appeals found that small quantities of drugs unaccompanied by evidence that the substances were packaged for resale were insufficient to raise an inference of intent to sell or deliver. In Wilkins, it was 1.89 grams of marijuana in 3 small bags. That defendant had a large amount of cash, $1,264. And the court there held that while small bags maybe typically used to package marijuana, it's just as likely that the defendant was a consumer who purchased the drugs in that particular packaging from a dealer. Here, it's our position that it's just as likely the defendant was a consumer who purchased the methamphetamine in that same baggie.
Why wouldn't the trial court be allowed, in weighing the totality of the circumstances, to look at the fact that there was some other unknown number of baggies that were available to the defendant? And just as you say, one aspect of looking at this is likely that it's just as likely it could have been something else. Potentially, to use the colloquialism, the trial court could have looked at it in the flip side way as well. Why would the trial court not be at liberty to assess in that vein?
The question, Justice Morgan, is whether it was a reasonable inference based on the totality of all of the circumstances of this particular case. And with respect to the baggies, I mean, that's really the only other piece of evidence that the state relies on to draw this inference of intent to sell or deliver. And so if we focus on those baggies were found inside the camouflage lockbox behind the passenger's seat. The number was uncertain. Nobody testified explicitly as to the number. Now, having said that, the bags themselves were admitted and published to the jury as part of the lockbox contents. I think that was State's Exhibit 15. But
I mean, and Mr. Vetrano, I don't want to deviate you too far from answering Justice Morgan's question, but it looked like both your brief and that of the state indicated without apparent disagreement that the prosecutor had argued to the jury there was something like 16 of them. Is that right?
Well, yes, Justice Ervin, so the state made sort of an unsworn oral proffer of 16 bags. The prosecutor counted those bags out after the close of all of the evidence, but that counting is, of course, not evidence. There's no record evidence where somebody said there were 16 bags or.
But presumably, if we were to get the exhibits sent to us, we could count the number of bags ourselves. And is there any real point in doing that, given that your colleague at the trial court didn't object to the prosecutor's statement? In other words, there's no reason to believe it weren't 16 bags.
I don't think so, Your Honor. I agree.
Okay,
agree.
thank you.
Justice Morgan, back to your question. You know, the state is citing Williams in their brief for the proposition that a jury can reasonably infer intent to sell and deliver from the presence of material that's normally used for the packaging of controlled substances. But that case is, Williams is, of course, very different from the circumstances that we have here. In Williams, for example, police knew that the defendant had sold heroin from his home. And then they went and searched a shed behind his house, and there they found a bag containing 10 to 15 tinfoil squares that the officers knew were commonly used to package heroin for sale. Here, the difference is that there's no evidence that this defendant had previously sold any methamphetamine. The empty baggies were found in the same location as the used syringe and the package of cotton balls, and the tourniquet, quite frankly. And Maxwell explained that that paraphernalia was used by drug users to inject methamphetamine. And the other case that the state cites is Coley, which on its face looks a little bit similar. And Coley, that defendant had 2 bags of marijuana, and he had an open box of baggies, cigar wrappers and cigars, and then he had 23 loose sandwich bags all strewn about his car. But the difference in Coley was that the defendant had a digital scale with him and $800 in cash, and the Court of Appeals there held that it was the additional presence of the scale and the large number of bags that created the jury question. Here, of course, there's no scale, no currency. And so when you're comparing the cases relatively, and the baggies are found under the padding in the defendant's use kit, meaning, you know, near the tools that he was likely using to inject methamphetamine, we think that more evidence would have been required for there to be a reasonable inference that those baggies suggested an intent to sell or deliver versus they contain drugs that at some point he consumed.
With these cases that you're mentioning, obviously they're fact specific. They're all fact specific in one way or the other. And with the totality of the circumstances being not at issue in terms of being a standard. Both parties agreed to that. Court of Appeals looked at it as well. How would this court find that the trial court erred in balancing the factors to be considered when it is a weighing aspect that the trial court has at its disposal?
You would have to conclude that intent to sell was mere speculation or conjecture. You would have to determine that where there were drugs found in one location of the car and baggies found in a use kit next to evidence that the defendant was using drugs, that doesn't meet the threshold of substantial evidence or sufficient evidence to overcome the motion to dismiss. It's really a quantity question. How much evidence is sufficient, and does this court want to set a precedent that where there's baggies and there's no explanation, there's no testimony linking those baggies to sale and delivery as opposed to use, is that enough? Is that the standard that we want to set for additional cases?
Well, the case law looks at quantity in terms of the fact that the quantity in and of itself, if it is enough, can be sufficient to establish the intent to sell and deliver. But on the other hand, in looking at a quantity, perhaps not to that level of quantity, but looking at it in connection with other circumstances, then the totality of the circumstances becomes the standard. In light of the relatively low bar in terms of a motion to dismiss being able to be overcome, plus the light most favorable to the state standard, plus the totality of the circumstances standard, where would this court draw a bright line, if any, or otherwise, how would we say that the trial court somehow did not look at this appropriately?
Your Honor, I don't think there is a bright line to be drawn because these cases are so fact specific. I mean, there's not a case that's directly similar to ours where you can sort of set a bright line standard. But you look at what was there in the car and you look at what was not there. So for example, you would also consider the defendant's statements and activities, which don't in of themselves or in combination with other factors support an inference of intent to sell or deliver. Remember, this car had never been seen at that residence. There was no transaction that was witnessed at the vehicle. There's no furtive movements, that Mr. Blagg was polite and cooperative throughout all of his interactions with law enforcement. And in even the statement that the state relies on, that after he was arrested, he offered to help the police apprehend this woman believed to be a heroin dealer that he called Haywood's Most Wanted. Maxwell testified that interaction itself was not unusual. He testified that, I mean, it's pretty common once you arrest somebody for possession of some sort of drugs, they want to try to help themselves. It doesn't tip the scales in favor of selling or delivering methamphetamine versus being a drug user who showed up at this house to get his next fix. I don't think there is a bright line rule. The question is this sort of quantum of evidence taken as a whole sufficient to get the state across the line where this case should be decided by the jury?
Let me ask you a question about the baggies, and correct me if I'm understanding this incorrectly. As I understand it, there were 16 baggies that were inside the lockbox.
Right.
Is that right? And
correct.
these were not ones that had substance residue in them. Is that?
Well, we don't know because there wasn't any testimony. All we know is that when the lockbox was unpacked in front of the jury, the state pulled out some of those baggies and displayed them as the state was publishing that exhibit. So, but there was no testimony. I think it would have been an interesting fact to know whether there was residue in them or not.
What, if anything, would have been a reasonable inference for the jury to draw from the fact that there were baggies in the lockbox with other usage paraphernalia?
That he was a drug user. That this was his use kit. These were his tools that he carried around with him, and that those bags were the remnants of methamphetamine that he had previously used.
even though we don't know? Would it matter for purposes of inference drawing whether we knew that the baggies had residue or not?
I think if the, I don't know, Your Honor. I don't know. I mean, I would certainly make the argument that if they were empty baggies that had residue in them, that it would suggest that he had used the contents of the bag, that he purchased it in those bags and then used that up. And it's just based on the location. I mean, that's me speculating based on the location of those baggies relative to the other items that were found back behind the passenger seat.
Were the actual baggies distributed to the jury to view?
They were published, yes. The prosecutor reached into the lockbox and apparently pulled some of those baggies out and displayed them.
Okay. So they would have probably been able to observe whether there was or wasn't residue?
Possibly.
Okay. Right. Just wondered your take on those things. Thank you.
So unless there are other questions, I'll stop. But I mean, our position is, of course, viewed in the light most favorable to the state. This evidence indicated that the defendant was a drug user, not a dealer. And so for those reasons, we're asking this court to vacate the conviction. Thank you.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court. My name is Nick Sanders, and I'm an Assistant Attorney General with the North Carolina Department of Justice, and I'll be representing the state in this matter. On January 4th, 2017, defendant was leaving a home that had been under surveillance when he committed a traffic violation and was pulled over by a deputy with the Buncombe County Sheriff's Office. During the traffic stop, a canine alerted to the presence of narcotics, and the following items, which you've already heard discussed some here today, were found during a search of defendant's vehicle. There was a clear plastic baggie containing what was later determined to be 6.51 grams of methamphetamine, 2 clear plastic baggies containing a crystalline substance, a clear plastic baggie containing marijuana, 16 empty plastic baggies, a bag of unused syringes, a bag of cotton balls, 1 loaded syringe, and some burned blunts. Defendant then told the officers after all of these items were recovered that he was to meet with an individual who was involved in the heroin trafficking, whom he called Haywood's Most Wanted. The Court of Appeals majority correctly determined that this evidence, when viewed in the light most favorable to the state and affording it every reasonable inference to be drawn from the evidence and ignoring any evidence that is not favorable to the state, that this evidence was sufficient to send the charge of possession with intent to sell or deliver methamphetamine to the jury. Now, the defendant does not contest that he possessed the methamphetamine, only his intent to sell or deliver. And as this court is well aware, intent is seldom proven by direct evidence, and it is often proven by circumstantial evidence. So I'd like to now turn to the evidence in this case, and beginning with the amount of methamphetamine that the defendant possessed. As this court has heard today, defendant possessed 6.51 grams of methamphetamine. And as the Court of Appeals correctly characterized this is not a small amount. There was testimony from Deputy Maxwell, who had been with the sheriff's office for almost 20 years and investigated or charged hundreds of drug charges. He put this amount into perspective for the jury. He testified that the typical amount of methamphetamine that is sold is between 0.5 gram and 1 gram. So based on this evidence, the jury heard testimony that defendant possessed 6.51 grams of methamphetamine, which would have been up to 13 times the amount of methamphetamine that is typically sold or purchased by an individual.
Mr. Saunders, if I understood Mr. Vetrano's response with respect to this point to the Chief Justice's question, and of course, if I misunderstood it, he can and I hope will correct me. I understood his argument to be that the mere fact that the methamphetamine was typically sold in amounts of the size that you indicate did not have any bearing on the issue of whether 6.1 grams was more than a personal use amount. I think his argument in essence was that you would need to have more direct testimony with respect to that issue before the jury could appropriately make an inference that this was more than a personal use amount in this instance. What's your response to that argument? And I hope I haven't mangled it so bad that you don't remember what the argument was.
Yes, Your Honor. I think what's important to remember is the stage that we're at. We're at the motion to dismiss stage, where the state, to survive a motion to dismiss, is only required to present evidence, substantial evidence of the element of intent to sell or deliver. And substantial evidence, as this court has defined, is evidence which would allow a reasonable juror to accept a conclusion or make a reasonable inference from the evidence. So what we're dealing with at the motion to dismiss stage are reasonable inferences. So the question is, when the state has presented evidence that the defendant has possessed 6.51 grams of methamphetamine and that the typical amount sold of methamphetamine is 0.5 gram to 1 gram, that is a reasonable inference to make that the defendant possessed up to 13 times the amount that is typically sold or purchased by an individual.
Is it the state's argument that it is a reasonable inference from the fact that the amount typically sold is 1/2 to 1 gram, that amount is a personal use amount that the other is not?
I'm sorry, Your Honor, if I understand your question. So I think the issue is not whether this evidence disproves personal use. If I'm understanding your question correctly.
Let me try again then.
Sorry, I apologize.
I was afraid I had not stated it very well. I had understood Mr. Petrano's argument to be, in essence, that you can't find an intent to sell or deliver in the event that all the evidence taken in the light most favorable to the state tends to show that we have nothing more than a personal use amount. I think that's essentially his argument. And he then further went on to say, if I understood him correctly, that the fact that methamphetamine is typically sold in 1/2 to 1 gram increments doesn't have any bearing upon whether you have a personal use amount or not if you've got as much as 6.1 gram. Is the state's argument that the testimony that methamphetamine is typically sold in 0.5 gram to 1 single gram amounts constitutes a reasonable proxy for what would typically be considered a personal use amount?
Sure. So I think what the defendant
trying to see what is the state's. My sense is that the state's response to the personal use argument lies in the testimony of the officer concerning what the typical amount sold is, and I'm just trying to make sure I understand the state's argument.
Correct, Your Honor. The state's argument is that when you have the actual amount of methamphetamine the defendant possessed, you have the officer's testimony of what typically constitutes a typical sale or purchase of methamphetamine. And then you have these other circumstances, as we will discuss here today, such as these clear plastic baggies, that all of this evidence could allow the jury to reasonably infer that the defendant intended to sell or deliver this methamphetamine. The state is not required to disprove personal use to survive a motion to dismiss. It's all of these circumstances together, and the question is whether that would allow any rational juror to accept the conclusion that defendant would intended to sell or deliver the methamphetamine.
On this point, I want to follow up on what significance we should give to the fact that the trial court instructed the state that it couldn't argue that this amount was more than for personal use because there was no evidence to that effect. And it sounds like you're asking us to rely on the jury making a reasonable inference that the trial court told the state it couldn't argue to the jury.
Well, Your Honor, I think you have to look at what the court actually prohibited the state from doing in context. So at that point, the trial court prohibited the state from directly arguing to the jury during closing argument that this methamphetamine was definitively not for personal use. So that's the limit of the trial court's prohibition, which was that the state could not make that affirmative definitive argument in its closing argument. that doesn't in any way diminish the evidence that was before the jury as to the amount of methamphetamine and then the typical amount that is purchased or sold. And so the trial court's limitation on the state's argument about personal use does not in any way prohibit or limit the jurors' reasonable inference from this testimony about the methamphetamine and the typical amount, that this would be more than a personal amount and that the defendant intended to sell or deliver that amount. So I don't think that the trial court's limitation on that in any way prohibits an inference to be made by the jury based on the amount.
Then what significant? So the fact that the trial court limited the state in that way is just irrelevant to our analysis. Is that your argument?
I don't think it affects whether the state survived the motion to dismiss, because I mean, as the state acknowledged, the state wasn't sure that the officer could even testify definitively to say this 6.51 grams was not for personal use. That is irrelevant. Whether the state could then argue that in its closing argument doesn't affect whether the state presented substantial evidence of an intent to sell or deliver. And the reason for that is because at the motion to dismiss stage, the state is not required to disprove every hypothesis of innocence. So if this 6.51 grams could be for personal use, as the Court of Appeals majority recognized that an argument could be made to the jury that this 6.51 grams was just for personal use. But that's not the inquiry at the motion to dismiss stage. The inquiry is whether the state has presented evidence which could allow the jury to infer that the defendant intended to sell or deliver the methamphetamine. And all the evidence is viewed in the light most favorable to the state in that inquiry, and any evidence that is not favorable to the state is discarded.
Much has been said about the amount being personal use versus sale and deliver quantity amount. What's the state's response to pretty healthy dissent from a length standpoint, certainly, in terms of talking about the dearth of what typically would accompany a sale and delivery or intent to sell and deliver aspect? No cash, the typical tools, to use the phrase of the dissent, not being found, such as scales and cutting agents, the aspect of there not being any lists of customers, those kinds of aspects. What's the state's response to the relative lack of what is typically associated with the offense?
Yes, Your Honor. And I believe, as you mentioned during the defendant's argument, these specifically the question of sufficient evidence of intent to sell or deliver is a very fact-specific inquiry. So in addressing the wide variety of facts that our courts are going to see in these challenges, our courts have created certain circumstances which might be relevant to determining an intent to sell or deliver. And in that, as you've mentioned, there are the presence of cash, the presence of ledgers. There are a number of different, in fact, non-exhaustive factors which might be relevant to the question of intent to sell. But the absence of certain factors is not dispositive to the state's case. I mean, if you look at any number of these cases, I would venture to say you're almost always going to find some of these factors not present in a case. So what the court has to do is look at the circumstances that are present and see if that survives a motion to dismiss. And in this case, that is correct. We don't have cash, which there might, I will say with cash, there might not always be cash because the charge is possession with intent to sell or deliver. So it might not be for an exchange of money. There were no ledgers. As the defendant pointed out, there was nothing incriminating found on his phone. So there are circumstances that could be, if they were here, relevant to the intent question, but that does not discount the evidence that the state did present with respect to intent to sell or deliver, such as the amount of methamphetamine, the presence of packaging material, defendant's activities, the presence of other paraphernalia, such as the cotton balls and the syringes, which we have testimony linking to the injection of methamphetamine into one's system. So the question, going back to answer your question, the absence of some of these factors does not in any way mean that the state failed to prove intent to sell or deliver to survive a motion to dismiss.
I asked your colleague on the other side the aspect of measuring the totality of the circumstances, and how would this court somehow find that when you've got a number of factors that the totality of the circumstances was not met. I'll ask you the converse. Are you offering here then that the state would be immune from having the totality of the circumstances operate against it because the dearth of the typical items would be of such lack of consequence in the measure of it all that that could not be held against the state?
Well, Your Honor, I would take exception to that there's a dearth of evidence that is typically found in cases of possession with intent to sell or deliver. We have an amount of methamphetamine that is up to 13 times more than the amount that is typically purchased and sold. We have 16 empty baggies that were in the same car as defendant. Defendant was the only individual in the car. So we have him with the methamphetamine, with the baggies. We have other paraphernalia that are associated with selling drugs, such as a bag of empty syringes. We have a baggie of cotton balls. And while certainly this evidence could be seen as personal use, it could also, when taking all of that together, let a rational juror infer the defendant, based on all of this evidence, intended to sell or deliver the 6.51 grams of methamphetamine that he had in his possession. So I don't believe that there's a dearth of evidence that would create some kind of lower bar in this case as compared to other questions of motion to dismiss. It was sorry.
No, go ahead and finish. I can wait.
I was just gonna, that's okay, Your Honor. I was basically done.
Okay, I was just going to ask in terms of what I posed again to your colleague on the other side. He says there's no bright line. I assume you would agree that there's no bright line, but where do we draw as a court some type of distinguishing aspect here in terms of looking at, to direct other trial courts, talking about the totality of the circumstances relative to, and while I said dearth, perhaps relative dearth would have been a better phrase for me to employ, in terms of looking at the fact that there's not the typical aspect of any cash versus no cash here, in terms of no ledgers here versus ledgers in other cases, the quantity of drug paraphernalia. Where would you suggest that we draw the line here, if a line can be drawn at all, in terms of talking about how to direct trial courts to assess the totality of the circumstances or lack thereof?
Yes, Your Honor. And respectfully, I don't believe there is a bright line. I would agree with the defendant to be drawn in this case. These cases are fundamentally fact specific, and you have to take the totality of the circumstances. So I would hesitate to start removing certain circumstances in this case to see whether that would survive a motion to dismiss or whether that is the bottom line. The fact is, in this case, that we have the evidence that we have, and that evidence that I've already discussed, the amount of methamphetamine, the packaging materials, the paraphernalia, defendant's activities, etc., that evidence is enough in this case to meet the standard for motion to dismiss. I don't believe by accepting this evidence as as sufficient to survive a motion to dismiss that would be somehow changing the bar or lowering the bar to say that the state can always survive a motion to dismiss. And these cases, again, are fact specific. So you just simply have to look at the circumstances that are present in this case and determine whether the evidence that the jury actually had before it, whether that is sufficient to survive a motion to dismiss. And I believe it is.
So I have a slightly different question, but along the same lines of the implications of the decision in this case. And I understand that every case is fact specific, but we always then look to the facts of the prior case to see how similar it is to the next one. And my question for you is, if we consider all the evidence that the state says it provides the substantial evidence that there was an intent to sell or deliver, if all that evidence is also equally consistent with a user, someone who is just purchasing this amount of, likes to have his store ready for the whole week, If the evidence in this case, and I realize you may not agree with me that it is, but if this evidence is equally consistent with someone who truly is just using the drug and not selling or delivering, then how do we avoid a situation where almost every case of anyone, possessing, I suppose, more than just minute amounts of the drug could be become a case where there's substantial evidence that can go to a jury on selling or delivering?
Yes, Your Honor. I think that's where the standard of review for a motion to dismiss comes in, because while you are correct that the evidence can establish an inference that the defendant was a personal user, but the evidence also can raise a reasonable inference that the defendant intended to sell the methamphetamine. That's a question for the jury. What is kind of a safeguard, which I think your question is getting to, or ask about, sorry, is that there has to be something more than mere speculation. So if you have a case where all the evidence points to personal use, and then to say that based on this evidence, an intent to sell or deliver would just be mere speculation, then that fails. So there is a safeguard in the motion to dismiss stage that would prevent and a complete absence of intent to sell or deliver from getting to the jury. But I mean, this court has expressed, or at least our Court of Appeals has expressed, that in borderline cases or closed cases in which reasonable minds can differ, that charge should go to the jury. The jury should be the one to decide that and actually weigh the evidence. So if you can look at a case and say, this evidence, I get a reasonable inference that this is only for personal use, but it's also a reasonable inference to say there was an intent to sell or deliver, then that case goes to the jury.
But it just seems to me that in the other cases, the other types of evidence that's lacking here, so, special typical tools that would be used to divide the drug, a customer list, a bunch of cash, guns. And I do think in cases you actually do have direct evidence of intent to sell where someone is, caught in the act of actually selling the drug. So it's not true that we never have direct evidence of intent to sell, but in the cases where you don't have direct evidence, it seems like all of those other types of evidence are things that are not consistent with merely being a user. And that's what distinguishes, that's what becomes substantial evidence sufficient to go to the jury.
And I do think you have that evidence present here. There is not an absence of other materials different than just the methamphetamine. We do have 16 empty plastic baggies, which the officer testified is based on his training and experience, is consistent with dealing and transportation of methamphetamine. So we have testimony about that. And I think the defendant argued that there was no link between the plastic baggies and the sale or delivery of methamphetamine, but that's not true. There is this evidence, there is this testimony by a seasoned detective that these baggies were consistent with dealing and transportation of methamphetamine. So you have more than just the methamphetamine here. You do have some of the, I believe someone might have called it the tools of the trade here. You have empty plastic baggies, you've had cotton balls, you have empty syringes. And while these might raise an inference of personal use, they also are something additional that would raise a reasonable inference of an intent to sell or deliver. So we do have stuff in addition to just the methamphetamine in this case. And this case is certainly distinguishable from a number of the cases that at least I know the dissent has cited, such as Nettles and Turner. For example, in Nettles, you had 1.2 grams of cocaine rolled in a napkin in the car. The defendant was in his home. The drugs were found in the car outside. And he had some money from a Social Security check. This is different from those types of cases because you have 6.51 grams of methamphetamine, which is 6 to 13 times the amount typically sold in a single baggie. And then you have 16 empty plastic baggies in the same vehicle with the methamphetamine. And then you have these additional paraphernalia, such as the cotton ball syringes, et cetera. So we do have more in this case to distinguish it from cases where this court has held that a motion to dismiss was proper. And if there are no further questions, I'd like to briefly sum up. The state has submitted substantial evidence that defendant intended to possess or deliver the methamphetamine. The charge was properly submitted to the jury to decide, and the Court of Appeals majority should be affirmed. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Chief Justice Newby. We don't have more here. I mean, there was no evidence that the state introduced that the cotton balls or syringes were items that were used in selling methamphetamine. You would have had to have some testimony about that. The testimony was that the tourniquet, the cotton balls, they were used by a user to inject methamphetamine, to filter methamphetamine. There was a bloody syringe in the kit. Somebody had used drugs in that needle. I agree with the statement that the fact that methamphetamine may or may not typically be sold in 0.5 to 1 gram quantities is not a proxy for what a typical user uses. You can't say whether an amount is substantial unless it's either more than personal use, which would require some testimony, or if you compare it to the trafficking threshold and it measures at a sufficiently high level compared to the trafficking threshold. We don't know whether this was a lot of methamphetamine or not. It may have been, as Justice Earle suggested, that this was a user who had purchased a supply to get him through a couple of days. We just don't know. That evidence raises at most a suspicion as to the commission of the offense. It's not substantial evidence. And of course, the baggies, we don't know what they were used for. They were in the kit with the tools that a user would typically use. We don't have any evidence that they were baggies that were intended to be used in sale, and we particularly don't have that because we don't have any mechanism for him to divide the drugs that were in the car up into those baggies and weigh those out for sale. So that it is important to be concerned about the implications of this particular case, where there's one bag of drugs, 16 baggies in a different location, and that evidence is more likely consistent with Mr. Blagg being a user of drugs than a seller. And for those reasons, and of course, the implications are serious. I mean, the dissent correctly noticed the fact that based on Mr. Blagg's prior record level and his habitual felon status, he was sentenced to 50 to 72 months for possession of methamphetamine, but for possession with intent to sell or deliver, he was sentenced to 128 to 166 months. That's a difference of 94 months or just under 8 years at the maximum ranges. This is a very significant consequence for defendants who find themselves in a similar position. So for those reasons, we asked the court to determine that this was evidence that was sufficient to raise at most a suspicion of intent to sell, and we ask you to vacate that conviction. Thank you.
Thank you, counsel. Thank you, everyone. Before we take our 45-minute recess, I want to note for the record, as I should have done at the beginning, that Justice Berger is recused in this case. That having been said, Madam Clerk, if you will announce our 45-minute recess, please.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court.